करवा दें। तो हमने जैसे ही हुआ हमें तुरंत फोन कर।
नहीं, आपके फोन से क्या होता है? मैंने मैडम देखिए, दो चीजें हैं, आप एक पर्सनल कैपेसिटी में अपेयर होती हैं और एक सुनिए तो पीछे का देख रहे हैं, एक रिप्रेजेंटेटिव कैपेसिटी में अपेयर होते हैं। जब रिप्रेजेंटेटिव कैपेसिटी में होते हैं, जब हम कहते हैं ना कि आपने किया, तो वो हमेशा रिप्रेजेंटेटिव कैपेसिटी में पूछा गया प्रश्न है, और जब हमको आपसे स्पेसिफिक पूछना होता है तब हम स्पेसिफिक पूछते हैं, मैडम आप ये शब्द बताइए।
सर एग्जीक्यूटिव
का बताइए, कौन आ गया है? जी सर, आपने वो रोड बंद कर दी है जिनकी प्राइवेट जमीन के ऊपर बनी हुई है, उतना ब्लॉक लगाया है आपने वहां पे क्या किया है कल आदेश के बाद? आप जितना पूछा जा रहा है उतना जवाब दीजिए, नहीं तो अभी मैं लिखो भाई। क्या नाम है आपका मैडम, प्लीज आपका नाम क्या है, या क्या पोजीशन है आपकी? ई है, कहाँ के हैं? रीवा डिवीजन की ई है, ई पीडब्ल्यूडी रीवा डिवीजन। आपका कहना प्रचलित रास्ता था, इसलिए अब आपका पूरा अधिकार है। लिखो भाई 13236, मैं फाइनली डिसाइड कर रहा हूँ, 13236/2024। This petition under Article 226 of Constitution of India has been। मैडम 15,000 रुपए पर डे के हिसाब से देते रहिए प्लीज। मैडम मैंने आपने सुन लिया ना, अब मुझे इस बात का दुख है, सुनिए मुझे इस बात का दुख है मैडम, इस बात का दुख है कि आपको लगा कि आपको ये तवज्जो देंगे। सुनिए मेरी बात सुनिए मैडम प्लीज सुनिए मैडम, प्लीज मैम, सर हो गया, धन्यवाद।
सर ये क्वेश्चन ये था
मैडम आप रुक तो जाओ, अरे आपके साहब को धन्यवाद तो दे लेने दो। हो गया सर, बैठे आप अपनी कुर्सी में, आप बैठ जाइए, कोई प्रॉब्लम नहीं है। मैडम जहां तक हमारे आदेशों की अवहेलना का सवाल है, हमारे पास कंटेम्प्ट का अधिकार है, हम तो हम करवा लेंगे। सुनिए तो, आपके आदेशों या रिक्वेस्ट या इंस्ट्रक्शंस की अवहेलना का सवाल है तो आपके पास कोई अधिकार है नहीं, है ना? तो वो अधिकार ना होने के करके अगर आपके आदेशों की अवहेलना होती है तो मुझे एक कॉन्स्टिट्यूशनल ऑफिस नजर आता है जिसको कि एजी ऑफिस कहते हैं, और वो कॉन्स्टिट्यूशन में प्रोवाइडेड है। अगर ऐसे अधिकारी जिनका कि जो खुद कानून से बंधे हुए हैं, आज अगर हम इनसे कहें कि आपको नौकरी से निकाल देते हैं हम, तो आज ही WA फाइल होगी कि हाई कोर्ट को मेरे 309 300 फलाना सिविल CCA रूल्स इसके खिलाफ जाके मेरी नौकरी से निकालने का अधिकार नहीं है, राइट? तो जिस संविधान से ये बंधे हुए हैं, उस संवैधानिक संस्था की बेइज्जती करने में इनको जरा सी भी हिचक नहीं होती है। चूंकि अब आपके पास कोई अधिकार नहीं है इनको याद दिलाने के लिए कि ये जिस संविधान से बंधे हैं उसके हिसाब से आपका ऑफिस एक संवैधानिक इंस्टीट्यूशन है, तो ये मेरा परम कर्तव्य हो जाता है कि कानून व्यवस्था को बनाए रखने के लिए, संवैधानिक संस्थाओं को बचाए रखने के लिए हम आपकी मदद करें। अब आप बताइए, अब आप बस इतना बताइए, आप संवैधानिक इंस्टीट्यूशन को बचाना चाहते हैं कि नहीं बचाना चाहते? अभी सुन तो लीजिए, अभी आप सुन तो लीजिए। अभी आपने कहा सब वो रोड ब्लॉक कर दी गई है क्योंकि हमने फोन किया। हमने फोन किया था, तो हमने कब फोन किया था, किसी ने माना क्या? मैडम सुनिए तो, हमने पूछा किसी ने माना क्या? आपने कहा हाँ पीछे बैठे हैं। उन्होंने क्या कहा? वो तो पूर्व से प्रचलित है सर। मैडम वो अधिकारी हैं जो फील्ड में काम कर रहे हैं, राइट? अगर आप उनको सर्टिफिकेट दे रहे हैं कि वो नाकाबिल है, अफसर है, उनको समझ नहीं है कानून की, आपका सर्टिफिकेट है, मेरा नहीं है, तो मैडम वो नौकरी में क्यों है? क्या आपका शासन नाकाबिल नकारा व्यक्तियों को नौकरी में ई के पद पे रखना चाहता है आपके हिसाब से? ये बता दीजिए। आपने कहा है कि उनको समझ नहीं है, मैंने नहीं कहा। मैंने तो उनकी बात को कानूनी बात मान के उसको डिसाइड कर रहा हूं कि क्या जो इन लोगों की समझ में ये फील्ड में काम कर रहे हैं, लोगों के अधिकारों की हत्याएं कर रहे हैं, उसके हिसाब से मुझे निर्णय करना है। आप कहते हैं कि इनको कानून की समझ नहीं है, मान लिया मैंने, आपका स्टेटमेंट है। नाउ इट इज योर ड्यूटी टू टेल मी कि व्हाई यू आर टॉलरेटिंग सच टाइप ऑफ ऑफिसर्स। नो मैडम, सॉरी, आई हैव गॉट द आंसर, आई हैव गॉट। मैडम आपने क्या कहा था? मैंने फोन कर दिया है एंड यू आर सो कॉन्फिडेंट कि साहब ये आपकी बात सुन लिया होगा इन्होंने। मेरे आदेश का तो साहब मैं तो अभी कंटेम्प्ट कर दूंगा, तो अंदर जेल भेज दूंगा, मुझे कोई प्रॉब्लम नहीं। आपके बातों का, अब आप मुझे ये बताइए सर, आपका ऑफिस अपार्ट फ्रॉम कॉन्स्टिट्यूशनल अथॉरिटी फर्स्ट लॉ ऑफिसर ऑफ द स्टेट है कि नहीं? ये आदमी जिसको आप नकारा कह रहे हैं वो आपकी बात पे तवज्जो नहीं देता है, जबकि आप इस विश्वास के साथ मेरे से कह रहे थे जब हमने फोन किया है कि इन्होंने वाकई ब्लॉक कर दिया होगा। और इसने क्या कहा? वो तो पहले से चल रही है, अभी कुछ नहीं हुआ आपके फोन के बाद, आप उसको प्रोटेक्ट कर रहे हैं। आप तो बस इतना बता दो कि सर हमारे संवैधानिक इंस्टीट्यूशन की धज्जियां उड़ने दीजिए, आप मत बुरा मानिए, हम तो सक्षम है अपने आदेशों की अवहेलना को निर्णय करने के लिए। आप अपना बताइए मैडम, क्या चाहते हैं?
इसमें मंडे
अरे आप अपने 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 इंस्टीट्यूशन के एग्जिस्टेंस के बारे में, मैडम मैडम प्लीज आप अपने इंस्टीट्यूशन के एग्जिस्टेंस के बारे में पहले बताइए। अभी आपने जिस विश्वास के साथ कहा था कि हमने फोन कर दिया है, ये एग्जीक्यूट हो गया होगा, आपके सामने आपने सवाल सुन लिया, आपका विश्वास धाराशायी हुआ कि नहीं हुआ? और एक संवैधानिक संस्था के निर्देशक अनुसार भी इन्होंने उनकी धज्जियां उड़ा दी कि हम आपको आपकी बात से नहीं सहमत है, राइट? तो हम तो इंस्टीट्यूशन की इज्जत करेंगे। 1 3 2 3 मैडम प्लीज, 1 3 मैडम मैं कॉस्ट बढ़ाता चला जाऊंगा, मैं पर डे 15,000 की कॉस्ट लगा रहा हूं और इन सज्जन से रिकवर होगी। देखते हैं सर, मैं क्यों पब्लिक एक्सचेकर के ऊपर बर्डन डालूं जब आपके हिसाब से ऐसे अधिकारी हैं जिनको कानून नहीं मालूम? मैं क्यों पब्लिक एक्सचेकर पे, मैडम जो मैं आप ही के वर्ड्स लिखाऊंगा कि इनको कानून नहीं पता।
टाइम पे अगर नहीं होगा तो थर्ड डे से
थर्ड डे पे हम तो जेल भेज देंगे। थर्ड डे में कहां लगाए हैं थर्ड डे? मैडम जेल जाने से डरते क्यों है? वो भी शासन का ही विभाग है, मात्र एक विभाग से दूसरे विभाग में ट्रांसफर करना है हमने। कौन सा विदेश भेज देना है हमने? काला पानी की सजा भेज देनी है? शासन के एक घर से शासन के दूसरे घर में। अभी आप शासकीय आवास में रहते हैं ना सर? हाँ, तो अभी तो शासकीय आवास है, क्या प्रॉब्लम है मैडम? 13236/2024 श्री चंद्रहास दुबे, श्रीमती स्वाति असीम जॉर्ज। क्या नाम है आपका सर? आ जाइए सर। श्री मनोज कुमार द्विवेदी, एग्जीक्यूटिव इंजीनियर, पीडब्ल्यूडी, रीवा डिवीजन, रीवा, is present in person on his own. On 21/5/2024, this court had passed the following order. Next, this petition under Article 226 of Constitution of India has been filed seeking the following relief. It is the case of the petitioner that the respondents are constructing a road on a part of his private land, and the said act of the respondents is contrary to the constitutional as well as a human right as enshrined under Article 300-A of Constitution of India, and the state cannot encroach upon the land belonging to the private individual without acquiring the same under Land Acquisition Act. On 21/5/2024, a specific statement was made by counsel for the respondent that on 25/2024, the State Council was directed to seek instructions in the matter, and accordingly, order dated 25/2024 was passed, which reads as under. Thereafter, on 21/5/2024, it was fairly considered by counsel for the respondent that a road is being constructed on a part of a private land belonging to the petitioner. But it was also submitted by counsel for the petition respondent that the road was in existence for the last 40 to 50 years, and now new road is being constructed and filling has also been done. Accordingly, the counsel for the respondents was directed to address the question as to whether this court, after applying the principle of adverse possession, can dismiss the petition on the ground of delay and laches, because right to property is a constitutional right under Article 300-A of Constitution of India, and pass the following order. When the case was taken up, this court inquired from Shrimati Swati Singh George, counsel for the state, as to whether the interim order passed by this court on 21/5/2024 has been complied with or not, and whether the road which is under construction on the private land of the petitioner has been blocked or not. It was submitted by Shrimati Swati Singh George that yesterday she has communicated to the responsible officers, and she hopes and believes that the officers must have carried out the interim order granted on 21/5/2024 and must have blocked the road. However, Shrimati Swati Singh George on her own submitted that Shri so-and-so, the executive engineer, PWD, Riva Division, Riva, is present in the court. Accordingly, it was inquired from Shri so-and-so as to whether the interim order dated 21/5/2024 has been complied with or not. It was submitted by Shri so-and-so that the road is in existence for the last 40 to 50 years, but it was fairly considered that a road is being constructed on a part of private land of the petitioner also. It is submitted by Shri so-and-so that it is true that the road is being constructed on a part of private land belonging to the petitioner, but it was submitted that The road is in existence for the last 40 to 50 years and it is being rebuilt. And at present, no further encroachment has been done. यही तो है ना?
एक टोटल 500 स्क्वायर।
मैडम मुझे मतलब मैं तो 1 इंच की बात कर रहा हूँ, फॉरगेट अबाउट कितनी है। 1 इंच इनकी जमीन आपने हथियाई कैसे? मैडम ऐसा कोई कानून बता दीजिए कि जब तक आप प्राइवेट व्यक्ति की 4 हेक्टेयर 4 एकड़ 4 डेसिमल जो भी आप चाहें, जब तक आप वो नहीं हथियाएंगे तब तक उसको आपका इंक्रोचमेंट नहीं माना जाएगा। बस इतना सा कानून बता दीजिए। मैडम उन्होंने तो अपने लिए कब्र खोद दी है, आप मुझे ऑर्डर रोक रही थी, तो आप मुझे इतना बताइए, कोई कानून बता दीजिए कि जब तक प्राइवेट आदमी की इतनी जमीन जब तक हम हथिया ना लेंगे जबरदस्ती, तब तक हम इंक्रोचर नहीं कराएंगे। क्या लिखा? is being done. Consider the submissions made by Shri So-and-so Executive Engineer, PWD, Riva. From the submissions made by Shri So-and-so, it is clear that the interim order dated 21/5/2024 has not been complied with, in spite of the clear instructions given by the Office of Advocate General. It is really unfortunate that the civil servants are not realizing the importance of the Office of Advocate General, which is a constitutional authority, and they are out and out to carry out their illegal activities as per their own whims and wishes. On 21/5/2024, this court had asked a specific question to the State Council as to whether the state can claim adverse possession against a private individual or not. However, Shri So-and-so, who was aware of the question which has been formulated by this court by order dated 21/5/2024, has once again stuck to his original stand that since the road is in existence for the last 40 to 50 years, therefore they are not at fault. बोले सिस्टर, ये क्या है मैडम? क्या है?
It is a similar issue which is being raised by some of the petitioners, and this honorable court was stand enough your lordship to indulge your lordship into the matter. The matter pertains to the same that the road has been constructed way back in the court.
साहब आपने एडमिशन कर लिया है कि ये प्राइवेट, so that is not
that can be the operative part of.
Sorry sir, मैं डील करूंगा, डोंट वरी।
नहीं सर, मेरा
ये तो सर ये तो कब्र खोदने के, सुनिए कब्र खोदने के बाद, अरे सुन तो लीजिए, उसके बाद जब ऊपर मिट्टी डाली जाती है ना सर, मृत शरीर को रखने के बाद, ये काम आपने वो किया है।
नहीं सर, मेरा विद ऑल रिस्पेक्ट
रहने दीजिए। हो गया सर, सॉरी देख लिया मैंने। अरे मुझे इतना ज्यादा समय नहीं लगता, मुझे मालूम है कौन सा पैराग्राफ देखना है जहाँ पे क्या मिलेगा। इट इज सबमिटेड बाय, किसका नाम लिखाऊं?
मैंने एक्सरसाइज की है कब आपको सर,
कोई बात नहीं। इट इज सबमिटेड बाय श्री मोहन सोसरकर, who was also sitting in the court, that since the question of ownership is a disputed question of fact, therefore what is the value of the land, what is the location of the land, what is the area of the land, who is the actual owner of the land, cannot be adjudicated by this court while exercising power under Article 226 of Constitution of India. Therefore, the petitioner may be directed to make a representation to the respondent so that they can decide the same in accordance with law. To buttress his contentions, the counsel for the respondent has also relied upon a judgment passed by a coordinate bench of this court in the case of Rajendra Singh Yadav versus State of MP, decided on 19th of March 2024 in WP number 20491/2021 bracket में इंदौर में, heard the learned counsel for the parties. Police. Now, it is further submitted by counsel for the respondent that सुन दो आप जो बोलोगे लिखाऊंगा. It is further submitted by counsel for the respondents that they may be granted some time to file a detailed reply. Heard the learned counsel for the parties. On 21/5/2024, the respondents have candidly admitted that, मैडम आप लोगों के चेहरे पे जो लाचारी है ना सर, वो कोर्ट के कारण से नहीं है, आपके इन अधिकारियों के कारण है जो आपके हिसाब से नकारा लोग हैं, राइट? मैं वो सब लिखाने वाला हूँ. It is further, वो तो भूल ही गया था. It is further submitted by the state council that so far as the statement made by Shri So-and-so is concerned, he does not know anything about the law, and therefore his statement may not be taken note of, and the respondents may be granted some time to file reply. Heard the learned counsel for the parties. On 21/5/2024, a categorical state admission was made by counsel for the respondent that the private land is also involved in construction of the road. Or once the ownership of the petitioner has not been disputed by the respondents, and once they have not disputed that by encroaching upon the land belonging to the petitioner, they are constructing a road, then it is suffice to mention here that admission is the best evidence. And under these circumstances, it cannot be said that any disputed question of fact is involved in the present case. What is this? So far as the submission made by counsel for the state that Shri so-and-so has no legal knowledge and therefore they may be granted some time to file return is concerned, the said submission is shocking even to the conscience of this court. If the state authorities are, if the state is of the view that their officers have no legal knowledge, then it is a high time for the state to consider as to whether such officers are to be retained in the service or not. How the state can promote the violation of the constitutional rights of the citizens of the country only on the ground that their officers have no legal knowledge. बोले सिस्टर, मैडम इसको जस्टिफाई कीजिए, मैं वो क्या जस्टिफिकेशन आता लिखा हूँ? How you are retaining such officers जो आपके हिसाब से जिनको लीगल नॉलेज नहीं है. Accordingly, the state council was directed to justify the stand as to how the state can take a defense that their officers are innocent and have no legal knowledge.
I'm not talking about legal knowledge. मैंने सिर्फ बोला कि questions है समझ नहीं पाया.
नहीं समझ पाया. अच्छी बात है मैडम. At this stage, it was submitted by counsel for the state that, in fact, her intention was, मोहन जी कह रहे चुप रहो, ज्यादा बोलोगे और फंसते जाओगे. The intention was not to communicate that the officer has no legal knowledge, but it is submitted that her intention was to submit that he might not have understood the question formulated by this court. The aforesaid explanation given by the state counsel cannot be accepted. At the beginning of the arguments, it was submitted by the state counsel that they have issued instructions to the respondents and have communicated about the interim order dated 21/5/2024, and the state counsel was sure that the officers must have complied that order. But once Mr. So-and-so, executive engineer, PWD, Riva Division, Riva, made a statement in the open court that the land in that the road is already in existence for the last 40 to 50 years, and merely a new road is being constructed, then it is clear that in spite of the clear communication of the question formulated by this court, communication of question by the AG office to the executive engineer, which was formulated by this court, the executive engineer PWD Riva is still of an adamant view that once the road is situated over the land in dispute for the last 40 to 50 years, then state has acquired the title and therefore they can construct the road. Accordingly, this explanation given by Shrimati Swati St. George that the executive engineer might have failed to understand the question formulated by this court is nothing but a very weak attempt to save their officers who, according to the state itself, are incompetent, having no knowledge of law. Now, the next question for consideration is as to whether the state can claim adverse possession against the private individuals or not. The question is no more as integra. Vidya Devi wala judgment line. The Supreme Court in the case of Vidya Devi versus so-and-so reported in 2020, volume 5, 2020, volume 2, SCC 569 has held as under court. Thus, it is clear that the state cannot take the defense of adverse possession against an individual. Surprisingly, the AG office is well aware of the law laid down by Supreme Court. And in spite of a clear communication by the AG office to the officers about the law as well as the question formulated by this court and the interim order granted by this court, Shri so-and-so, executive engineer, PWD, Riva Division, Riva is adamant to say that since the road is in existence for the last 40 to 50 years, therefore, they are right in constructing a new road by raising the height of the road. That is the height of the arbitrariness and mala fide action on the part of Shri so and so, Executive Engineer PWD, Riva. Thus, it is clear that the attitude of Shri so and so is not indicative of lack of knowledge, but it is an indicative of the hostile attitude towards the law, as well as the authority of the court. The Chief Secretary, State of Madhya Pradesh, is directed to take immediate action against Shri so and so for having his hostile attitude in spite of the clear instructions issued by the Office of Advocate General and in spite of the interim order granted by this court for the system. ये विद्या देवी वाला ये है. Paragraph 12 to 19. नहीं 12 तो पूरा 12 ही लीजिएगा, 12 से लेकर 12.14 तक. Well, sister. So far as furthermore, the Supreme Court in the case of Kolkata Municipal Corporation and another versus Bimal Kumar Shah and others decided on 16/5/2024 in civil appeal number 6466/2024 has held as under. वो 7 guidelines हैं, वो पूरा लिख लीजिएगा. Thus, the action of the respondents in constructing a road on the private land of the petitioner is held to be unconstitutional, violative of constitutional right of the petitioner as enshrined under Article 300-A of Constitution of India, as well as violative of his human rights. Therefore, the respondents are directed to immediately, Madam सुन लीजिए, to immediately remove the road situated on the private land of the petitioner and submit the report latest by tomorrow before the Registrar General of this court. Police system. और मैं contempt notice भी issue कर रहा हूँ on the basis of his statement. Police system. So far as the judgment relied upon by counsel for the respondents decided by a coordinate bench of this court in the case of Rajan Singh Yadav is concerned, this court in exercise of power under Article 226 of Constitution of India is not required to decide the quantum of compensation. This can be done only by the land acquisition officer. Therefore, this court is not required to consider the location of the land, the existing market price of the land, the extent of the private land encroached upon by the state authorities. Furthermore, in the case of Rajan Singh Yadav Sopra, the coordinate bench had also held that such a petition cannot be dismissed on the ground of delay and laches. Thus, the judgment relied upon by the state council is in fact against the state council rather than supporting the cause of the state council. Well, sister. Next. Since the respondents have illegally encroached upon the land belonging to the petitioner and are raising the construction of a road without acquiring the same, and in spite of the notices issued on 25/2024, and in spite of interim order dated 21/5/2024, have not stopped the use of the land as a road. Therefore, the respondents are directed to pay a mean profits at the rate of rupees 15,000 per day to the petitioner till the road is actually dismantled from the land belonging to the petitioner. They said that since the said illegal activity of not complying the interim order is on Shri so-and-so, Executive Engineer PWD, Riva Division, Riva, therefore, this court would not like to put an additional pressure on the public exchequer, and therefore it is directed that the mean profits shall be recovered from the salary of Mr. So-and-so. Full stop. The Principal Secretary PWD is directed to submit his affidavit to the registry of this court, clarifying that how much mean profits has been paid to the petitioner and whether it has been deducted from the salary of Shri so-and-so, Executive Engineer PWD, Riva Division, Riva or not. And if the mean profit is not paid or the said amount is not recovered from the salary of Executive Engineer PWD, Riva, then The Principal Secretary PWD shall also be under obligation to explain that why no such action has been taken. Let the report be filed latest by 31st of May 2024. Full system. This, with a foresight observation, the petition is allowed with cost of rupees 25,000 to be deposited by Shri so and so within a period of 1 month from today, failing which the Registrar General shall not only initiate the proceedings for recovery of cost, but shall also register a case for contempt of court. As already pointed out, Shri so and so had made a statement that the road is already in existence and no blockages and it has not been blocked. However, it was his contention that it is not being used as road. Whether it was being used as road or not is a disputed question of fact. But once this court, by its interim order dated 21/5/2024, had directed the respondents that the private land shall not be used for road purposes, then it was obligatory on the part of Shri so and so that the hurdle should have been created so that no one can encroach upon the private land of the petitioner. In spite of the fact that the State Council was under a misconstrued hope and belief that Shri so and so must have carried out their restrictions about the stoppage of use of the private land as road, surprisingly and shockingly, Shri so and so did not listen even to the Office of Advocate General. Since Shri so and so has violated the interim order dated 21/5/2024, therefore issue show cause notice to Shri so and so as to why he may not be punished for committing contempt of court by violating order dated 21/5/2024. Office is directed to register a separate case for the said purposes and list the said case after the notices are served. मैडम अब आप लोगों को सुनेंगे ये, और अब आप बता दीजिएगा कि आपने सीएस ने अब क्या किया है। आपने सर्टिफिकेट दिया, मैंने तो दिया नहीं। आपने कहा उनको समझ में नहीं आता, तो हमने उस वर्ड को और रिफाइन करके लीगल कह दिया। अगर हम कह देते उनको कुछ नहीं समझ में आता तो ये तो सामान्य भाषा में भी चले जाते। फिर आपने कहा प्रश्न नहीं समझ पाए, तो ये तो आप अपने ही विश्वास से धोखा खा गए मैडम। चलिए।